Brooke Wooten, school board member.
Good evening, Ward McDaniel, Board of County Commissioners.
Andy Shove, citizen business owner.
Sandy Quinn, Board of County Commissioners.
Introduced, and
Andy Smith, Hannon Insurance Citizen.
And if we could have, is the clerk present or is her designee?
The clerk is not present, but the clerk is Becky Norris, and the clerk designee is Leanna Roberts. And we also have
Thank you,
Mitch Burke and Dennis Barfield Jr. from the Property Appraiser's office present.
Thank you.
The first order of business is you will need to appoint your private board counsel.
So we need a motion to appoint board counsel, which
Yes,
recommendation
please.
would be you, Ms. Chestnut, right? I entertain a motion that we move forward with the recommendation for Ms. Chestnut as board counsel.
I'll second that.
second,
Who made the motion?
I'll make a motion to.
didn't you make it, Andy?
I believe Chairman Quinn made the motion.
I'll second.
Okay, all in favor?
Aye.
Yeah.
So who,
Any opposition?
there were a lot of seconds there, so who are we calling to be the second?
Your choice.
Okay, thank you.
Your next order of business will be to elect your chairperson, and that must be one of the Board of County Commissioners.
If I could, I'd like to make a motion just to, if we can leave it like it is, Mr. Quinn be chairman and Mr. McDaniel vice chair. Make the motion.
Second.
Okay, there is a motion and a second on the floor.
Shove, correct? Thank you.
All in favor?
Aye.
Any opposition?
Thank you, Mr. Quinn.
You still there, Rachel?
Houston, we have a problem.
Rachel, you still there?
We just lost her. I hope she calls back.
Okay, thank you.
We may just have to declare a mistrial. Yeah, same old, that's what I told him.
Rachel Chestnut?
Rachel, you back on?
Yeah, I think so. Can
Okay,
you hear me
great.
now?
Yes. So we're at number 7?
Okay. Yes.
Okay. Thank you.
Those rules are available online and also in the clerk's office. I'm going to discuss a little bit about the Sunshine Law. And I think most of you are familiar as being other office holders and have previous service on Value Adjustment Board. Meetings of the public boards, which includes the Value Adjustment Board, must be open to the public. Reasonable notice of the meetings must be given, and minutes of the meetings must be taken and made available for public inspection. The general rule regarding the Sunshine Law is do not conduct business on a Value Adjustment Board issue with other Value Adjustment Board members outside of a publicly noticed meeting in the absence of recorded minutes. What that means is you as Value Adjustment Board members shouldn't be discussing any cases that may come before you unless you're in a hearing. Reasonable notice means that there must be public advance notice of a meeting, which gives the public sufficient time to be present at the meeting. That's going to be a little different this year because with the pandemic, we may be doing Zoom hearings, which I'm going to stress to you that there may be some other things that happen this year doing Zoom meetings, like one of the resolutions that I'm going to have you consider is your evidence copies will include a provision that if a party is appearing by Zoom or phone, they have to have their evidence in early. However, you as a board member cannot look at the evidence until the actual time of the hearing. So we're just going to have a little few tweaks this year. The clerk will be keeping your board minutes, and she will prepare a written summary of the board's meetings and have them available for public inspection. All board meetings will be recorded, and the recordings are public record also. Any worksheets or notes that you create while you're in a board hearing become part of the public record. So just kind of try to remember that if you're making notes, those are public record. Moving on to number 9, the local administrative procedures. The first one is the evidence copies resolution, and that's on page 7 of your packet. That is the resolution we've been doing. It provides that 7 copies are to be submitted of evidence, so each of you will have your own copy to look at during the hearing. I have included another provision, the 3rd paragraph on there, which does provide that if the party is appearing by Zoom or phone, that they will submit their evidence one business day prior to the hearing to the clerk so she can have copies available to the board.
Did we lose you again, Rachel?
I'm still here.
Oh, okay, all right.
So the board should consider the resolution regarding the evidence copies. And is there a motion to
Yes.
adopt that?
I'd like to make a motion to adopt the local administrative procedures of 2020 as referenced.
I'll second that motion.
All in favor?
Aye.
Aye.
Any opposition? Okay, thank you. And the second resolution is a resolution regarding the filing fee. Florida statutes allow you to institute a $15 per parcel petition filing fee, and that offsets your fees a little bit. I would ask that the board take that into consideration and adopt it.
Make a motion.
Second.
All in favor?
Aye.
Any opposition? Thank you. And now I am going to give you a general discussion about how the property tax system works. Each county has a value adjustment board with 5 members, 2 members from the county governing board, 1 from the school board, and 2 citizen members. The value adjustment board hears appeals filed by taxpayers regarding certain determinations of the property appraiser or tax collector. The board conducts hearings and takes testimony in order to decide whether to grant or deny a taxpayer's appeal. The board clerk has several duties. It's her duty to determine that the board has met all of the requirements for the organizational meetings prior to the board holding hearings. She makes petition forms available to the public upon request, receives and acknowledges completed petitions, and furnishes copies of all completed and timely filed petitions to the property appraiser or tax collector. She schedules hearings, sends notices, and is the official record keeper for the board and maintains a record of the proceedings. My role as the board's legal counsel is to advise the board on all aspects of the value adjustment board review process to ensure that all actions taken by the board meet the requirements of law and ensure that the proceedings are fair and consistent with the law. The property appraiser assesses all property located within the county each year and prepares the real property assessment roll and the tangible personal property assessment roll. There are 4 ways that taxpayers have to appeal property assessment determinations. Taxpayers have the right to attend and give opinions at the public hearings where local taxing authorities consider the amount of the proposed property tax and millage rate. If a taxpayer disagrees with the property appraiser's assessment on his or her property, or if they were denied an exemption or classification, and they believe this denial was an error, the taxpayer has the right to discuss the issue with the property appraiser in an informal conference. And a lot of times, issues are able to be resolved that way. Or the taxpayer may file an appeal to the value adjustment board. The taxpayer can do either or both at the same time and can also file a lawsuit in the local circuit court to challenge the assessment. Taxpayers can also appeal if the tax collector has denied an application for tax deferral. The petitioner taxpayer is responsible for completing the petition form, paying the appropriate filing fee if required, and is responsible for presenting his or her evidence to the board, either in person or by submitting it to the board clerk prior to the hearing and requesting that the board consider the evidence without the petitioners present. Exemption or classification appeals must be filed within 30 days after the property appraiser mails the notice that the application was denied. Assessment appeals must be filed within 25 days after the property appraiser mails the trim notice, which was August 7th this year. If an appeal is filed after the filing deadline, the board or its designee will have to determine if there is good cause to allow the late file petition to be heard. I would ask the board to entertain a motion on who should make that determination if necessary. The board can make the determination in a public hearing, or you can designate your clerk or board attorney to make the determination. And what you've done the past few years if you had designated the clerk.
I make a motion, we designate the clerk.
All in favor?
Aye.
Aye.
Any opposition? Thank you. After the taxpayer has filed a petition, the clerk sends them a notice with the date, time, and location of the value adjustment board hearing at least 25 days before the hearing date. A taxpayer or the property appraiser may request that a hearing be rescheduled a single time for good cause, which means circumstances beyond the control of the person seeking to reschedule the hearing, which reasonably prevent him or her from having adequate representation at the hearing. The board or its designee will have to decide if the reason stated meets the good cause requirement. So I would ask the board to entertain a motion on who should make that good cause determination if necessary. And like the other, you have designated the clerk in the past.
So moved.
Second.
All in favor?
Aye.
Any opposition? Thank you. The taxpayer has the option of exchanging evidence with the property appraiser before the hearing. However, if the property appraiser asks in writing for specific evidence before the hearing, and the taxpayer has access to the evidence and refuses to provide it, then that evidence cannot be used during the hearing. If the taxpayer chooses to participate in the exchange of evidence, they must give the property appraiser a list of evidence and copies of documents they intend to use at the hearing at least 15 days before the hearing date. The taxpayer can request the property appraiser provide them with similar information, and the property appraiser must provide that at least 7 days before the hearing. If a taxpayer is able to resolve their issue with the property appraiser after filing a petition, but before the hearing, the taxpayer should withdraw the petition in writing to the clerk, and the hearing on that matter will be dismissed. At a value adjustment board hearing, the taxpayer may represent themselves, have an attorney represent them, or have an agent, family member, or friend represent them. If someone other than a licensed professional will be representing the taxpayer, then the taxpayer must provide written authorization or a power of attorney for the agent to represent them. At a hearing, the taxpayer and the property appraiser will each have an opportunity to present evidence. After the opening of the hearing, the property appraiser must first establish by preponderance of the evidence that the assessment is based on the 8 factors of just valuation set out in Florida Statutes 193.011, and that he has complied with professionally accepted appraisal practices in making the determination of the assessment. If the property appraiser proves that, then his assessment is presumed correct. However, a taxpayer may overcome the presumption of correctness by proving by a preponderance of the evidence that the assessed value does not represent the just value of the property, or that the assessed value is based on appraisal practices different from the appraisal practices generally applied by the property appraiser to comparable property within the county. If the property appraiser does not establish a presumption of correctness, or if the taxpayer is able to overcome that presumption, then the Value Adjustment Board shall establish the correct assessment if there's competent substantial evidence of value in the record, which meets the criteria of Florida Statute 193.011 and professionally accepted appraisal practices. If there is not such evidence, then the assessment must be remanded back to the property appraiser with the appropriate directions from the Value Adjustment Board, and the property appraiser must comply with those directions in determining a revised assessment. Florida law provides certain rights for property taxpayers. The 4 primary categories of taxpayer rights contained in Florida Statute 192.0105 are: number 1, the right to know, which includes the right to receive notices and be informed about various aspects of the property tax. Number 2, the right to due process, which includes the right to an informal conference with the property appraiser, to file Value Adjustment Board petitions, to receive notices of results from the Value Adjustment Board, and to file lawsuits. Number 3 is the right to redress, which includes the right to discounts, refunds for overpayment of taxes, and to redeem tax certificates sold for delinquent taxes on real property. And number 4, the right to confidentiality, which includes the right for certain taxpayer records to be confidential, consistent with the provisions of the law. All of the documents that I've talked about today can be found online on the clerk's website and Department of Revenue's website. And the clerk has copies in her office for people who don't have computer access. we had discussed a tentative schedule for our VAB hearing with the first date being set for September 28th. And we are working on coming up with a date for the rescheduled hearings.
We're looking at October the 6th. The school board has a meeting that morning, so it'll be the afternoon, starting at 1,
Okay.
if that's good with the boards.
Wait a minute, question. We're gonna stay with September the 28th, or we advancing it to
yes,
October the 6th?
September 28th and October the 6th, 2 hearing dates.
Okay, we're gonna go from the 1st to the 6th. Is that correct?
That is
In
correct.
October?
Yes, sir.
All right.
If the board is good with those dates, yes.
Is that all right with you, Brooke?
Yes, sir.
Okay, I think the only other thing we have to do is there are 2 sets of minutes from last year's board that we would ask to have the board approve.
October 6th. All right, I'll make a motion that we approve the minutes for October the 7th, 2019.
Second.
And October 14th minutes, both sets?
You want to bundle them? We
Yes,
can
sir.
bundle them, do
You
them?
can- yes, sir.
And 14. Thank you.
Thank you.
All in favor?
Aye.
Any opposition?
Nope.
Unless there are any questions for me, that was all that I had for you today.
So the two dates are
28 and 6th.
September 28th and October the 6th.
What's the time on them now?
Well, the one for the 6th will be 1 p.m.
10/6 is going to be 1 p.m.? Is
It'll
that-
start at
I'm
1.
good now, fellas. It's up to y'all.
But September 28th, they'll probably start 9:30 or 10 in the morning. It'll be
All
earlier.
right, it'll be a morning meeting.
Yes, sir.
All
But the
right.
6th will be just
Make
if
it
needed.
good for these gentlemen here. I'm good. It don't matter to me.
I'm sorry, what
The
did
6th will be.
Yes, the
if
6th will
it's
just be if we have to have a makeup
Yeah,
day.
if we just need it.
If we need it.
Yeah.
If we
okay.
need it.
All right.
Okay.
Yeah, I'm good whatever time on the 28th.
9:30 or 10. She wasn't sure.
And hopefully I will have all my technical issues worked out by then.
I'm sorry, Andy, what did you ask me?
we're wondering, is it 9:30 or 10 on the 28th? The time to start.
Are y'all okay with starting it at 9:30 and then we'll just go? Okay, so we'll start them at 9:30.
9:30. Great. And the 10/6 is pending.
All right.
So we just need a motion to adjourn if there's no other business.
So move.
That it?
Second.
Second.
Who seconded?
Doesn't matter.
I'll just put Andy.
You say leave.
Yes, sir. Thank you.